Welcome back to US Updates Hub. Today's video may be one of the most important updates covered this year. If you are from one of 75 countries whose immigrant visas have been paused, or if you have a family member waiting overseas for a green card, please do not click away. In the next few minutes, we are going to walk through everything that is happening right now. Explain why interviews at United States embassies and consulates are still being scheduled, even though visa issuance is frozen, break down the lawsuits that could change things, cover the brand new visa bond expansion to 50 countries, and give you clear practical steps you can take today. As of now, the pause is still in effect, but there are real developments you need to understand. Before we go any further, complete transparency is important. This video is for educational and informational purposes only. It is not legal advice. Immigration policies are changing fast, and what is shared here may be updated by the time you watch it. Always confirm any detail with official government sources like the Department of State, USCIS, or the Department of Homeland Security. And if your case is affected, please speak with a qualified immigration attorney. Now let us go through the full picture. Let us start with some background so everyone is on the same page. On January 14, 2026, the United States Department of State made a major announcement. It said it would indefinitely pause the issuance of immigrant visas for nationals of 75 countries. The reason given was that people from those nations were at what the government called high risk of public benefits usage. In simple terms, the State Department said immigrants from those countries were too likely to end up relying on government assistance programs once they arrived in the United States. The pause went into effect 1 week later on January 21, 2026. This was reported by multiple credible news outlets and described as one of the broadest changes to legal immigration processing in decades. Now, this is separate from another policy called Presidential Proclamation 10998, which is a travel ban affecting 39 countries that restricts both immigrant and non-immigrant visas based on national security grounds. That ban took effect on January 1st, 2026. So right now, we have two different restrictions running side by side. The 39-country ban under the presidential proclamation deals with security screening concerns. The 75-country pause is based on public charge concerns. They overlap for some countries, but they are legally different actions, and that matters for how they might be challenged in court. Let me read you the full list of the 75 countries so you know exactly who is affected. The countries are Afghanistan, Albania, Algeria, Antigua and Barbuda, Armenia, Azerbaijan, Bahamas, Bangladesh, Barbados, Belarus, Belize, Bhutan, Bosnia and Herzegovina, Brazil, Burma, Cambodia, Cameroon, Cape Verde, Colombia, Côte d'Ivoire, Cuba, Democratic Republic of the Congo, Dominica, Egypt, Eritrea, Ethiopia, Fiji, the Gambia, Georgia, Ghana, Grenada, Guatemala, Guinea, Haiti, Iran, Iraq, Jamaica, Jordan, Kazakhstan, Kosovo, Kuwait, Kyrgyzstan, Laos, Lebanon, Liberia, Libya, Moldova, Mongolia, Montenegro, Morocco, Nepal, Nicaragua, Nigeria, North Macedonia, Pakistan, Republic of the Congo, Russia, Rwanda, St. Kitts and Nevis, St. Lucia, St. Vincent and the Grenadines, Senegal, Sierra Leone, Somalia, South Sudan, Sudan, Syria, Tanzania, Thailand, Togo, Tunisia, Uganda, Uruguay, Uzbekistan, and Yemen. If your country is on that list, or if you have a family member from one of those countries waiting for an immigrant visa, this directly affects you. Now, here is the part that confuses a lot of people, and it is actually the most important thing to understand today. The title of this video says Interviews Continue, and that is 100% true. The State Department's own website, which is travel.state.gov, confirms that immigrant visa applicants who are nationals of affected countries may still submit visa applications and attend interviews. The department will continue to schedule visa interviews. What is paused is the final step, which is the actual issuance of the visa. So picture it this way. You go through all the paperwork, you get scheduled for your interview, you fly to the embassy, you sit down with a consular officer, you answer all the questions. But at the end, instead of getting your visa approved or denied, your case just sits there. The visa is not issued. It is not denied either. It is simply paused. This is an incredibly stressful situation for families because you are doing everything right. You are following all the rules and the process just stops at the last moment. Now, why would the government keep scheduling interviews if they are not going to issue the visas? There are a few reasons. First, the State Department says this is a pause, not a permanent ban. By continuing to process applications and conduct interviews, they are keeping the pipeline moving so that when and if the pause is lifted, visas can be issued relatively quickly. Second, it allows consular officers to complete their review and have a decision ready. Third, from a legal standpoint, calling it a pause rather than a ban gives the government more flexibility. The State Department has also clarified some exceptions. Dual nationals who apply using a valid passport from a country that is not on the list are exempt from the pause. Children being adopted by American citizens can qualify for a case-by-case exception, including a national interest exception, under Presidential Proclamation Tone 998, if applicable. The State Department says those American families should continue the normal adoption process and attend their interviews. Also, no immigrant visas that were already issued before the pause have been revoked. And importantly, this pause is specifically for immigrant visas. Tourist visas, student visas, and other non-immigrant visa categories are not directly affected by this particular action, though they may be affected by the separate 39-country travel ban. Let me now talk about what is happening in the courts because there is active litigation challenging this pause. The biggest case right now involves a lawsuit filed on February 2, 2026, in the United States District Court for the Southern District of New York. The case was brought by immigration advocacy organizations, along with individual plaintiffs from many of the affected countries. The lawsuit argues that the 75-country pause is an unlawful nationality-based restriction on legal immigration. It claims the policy violates the Immigration and Nationality Act as well as the Administrative Procedure Act. The plaintiffs say the State Department imposed a categorical restriction on immigration from these countries on what they call unsupported grounds. Immigration legal organizations have published detailed explanations noting that even though the State Department found that individual applicants from these countries were not likely to become a public charge, their visas were still being paused simply because of their nationality. As of late March 2026, the case is still ongoing. Court filings show that legal memoranda have been submitted, and the case is moving forward. There has not yet been a final ruling or broad injunction as of the recording of this video, but the case is progressing. There was also an earlier case filed in federal court in Nevada where a judge issued a temporary restraining order for a specific family, which means the court required the State Department to process that one family's visa. While that ruling was limited to just that one case, legal experts say it set an important precedent, showing that courts can intervene. Multiple news outlets covered these legal developments. Now let me also bring up the visa bond expansion because it connects to this larger picture. On March 18, 2026, the State Department announced that it was adding 12 more countries to its visa bond program, bringing the total to 50 countries. Effective April 2, 2026, travelers from these 50 countries applying for B1 business or B2 tourist visas may be required to post a bond of up to $15,000 as a condition of receiving their visa. The 12 new countries added are Cambodia, Ethiopia, Georgia, Grenada, Lesotho, Mauritius, Mongolia, Mozambique, Nicaragua, Papua New Guinea, Seychelles, and Tunisia. News outlets reported on this expansion and noted the bonds are meant to discourage visa overstays. The idea is that if someone posts a $15,000 bond and then overstays their visa, they lose that money. If they leave on time, the bond is returned. This is a significant financial burden, especially for people from developing countries, and it adds another layer of difficulty to the immigration process. So, what does all of this mean for you, and what can you actually do? Let me give you some real-world examples and practical steps. Imagine a woman from Nigeria. Her husband is a United States citizen, and he filed a family-based petition for her 3 years ago. She was finally scheduled for her interview at the embassy in Lagos. She attended her interview in February, and everything went well. The consular officer told her the case looked strong. But because Nigeria is one of the 75 countries, her visa was not issued. Her case is now sitting in administrative pause. What should she and her husband do? First, they should not panic. The interview is done and documented. If the pause is lifted, her visa could be issued relatively quickly. Second, they should keep all their documents current. Medical exams expire, police certificates expire, and financial documents go stale. They need to make sure nothing lapses while they wait. Third, they should consult with a qualified immigration attorney about whether they have any legal options, such as joining one of the existing lawsuits or exploring whether the dual nationality exception might apply if she holds a passport from another country. Here's another example. Think about someone from Colombia who was approved for a diversity visa in the 2026 lottery. Diversity visas must be used by the end of the fiscal year, which is September 30th, 2026. If the pause is not lifted before then, that person could permanently lose their opportunity because diversity visas cannot be carried over to the next year. For someone in that situation, time is extremely critical. They should be in touch with an immigration lawyer immediately to explore whether there are legal avenues to require processing of their case before the deadline. Now let me give you the practical steps that apply to everyone. Step 1. Check your case status regularly. If you have a pending immigrant visa case, log into the Consular Electronic Application Center on the State Department website. Make sure your contact information is up to date so you receive any notifications. Step 2. Keep every single document current and organized. That means updated financial affidavits, employment letters, tax returns, medical exams, and police clearances. If something is about to expire, get it renewed now. Step 3. Understand the difference between the 75-country visa pause and the 39-country travel ban. They are different policies with different legal bases and different potential outcomes. Knowing which one applies to your case helps you and your attorney develop the right strategy. Step 4. Follow the lawsuits. The major legal challenge in the Southern District of New York is the most significant. If the court issues a broad injunction, it could require the State Department to resume visa issuance for all 75 countries. You can follow case updates through immigration legal organizations or through court tracking websites. Step 5. If you are a dual national, check whether you can apply using a passport from a country that is not on the list. This is explicitly allowed under the State Department's own guidance. Step 6. Do not ignore your interview appointment even though visas are paused. The State Department is still conducting interviews, and having your interview completed means your case is further along in the process. Step 7. If you are affected by the new visa bond requirement, start planning financially now. $15,000 is a lot of money, but the bond is refundable if you comply with your visa terms. Talk to your attorney about how the bond process works and what happens to your money. Step 8. Be very careful about anyone who promises they can get around the pause or the ban. There are unfortunately scammers who prey on desperate families. No one can override a State Department policy. Only a court order or a change in government policy can lift the pause. Work only with licensed attorneys or accredited representatives. Let me also address something for those of you who are already in the United States. If you are applying for adjustment of status inside the country through USCIS, the 75-country pause does not directly affect you because that process is handled by USCIS domestically, not by a consulate overseas. However, the broader public charge scrutiny still applies. As of March 2026, the 2022 DHS public charge rule remains in effect, but the administration has proposed rescinding it and replacing it with stricter standards. This means that even for domestic applications, immigration officers may be looking more closely at whether applicants have used or are likely to use public benefits. Immigration legal resource organizations have updated their public charge guidance as recently as late March 2026, and checking their resources is recommended if you are concerned. One more important point for people who already hold valid immigrant visas. The State Department has confirmed that no visas issued before the pause have been revoked. If you already have a valid visa in your passport, you should consult with an attorney about your situation, but the pause itself does not cancel existing visas. For questions about admission to the United States with an existing visa, the State Department refers people to DHS and Customs and Border Protection. This is a lot of information, and it can feel overwhelming, especially if your family is separated right now because of this pause. Know that you are not alone. Tens of thousands of families across the world are in the same situation. Lawyers are fighting in court, advocacy organizations are pushing back, and the situation is not permanent, even if it feels that way right now. The most important thing you can do is stay informed, stay prepared, and make sure you have good legal guidance. Before wrapping up, let me quickly summarize. 75 countries are affected by an indefinite immigrant visa issuance pause that started January 21st, 2026. Interviews are still being scheduled and conducted at embassies and consulates. A major lawsuit filed in the Southern District of New York is the significant legal challenge, and it is still ongoing. A separate 39-country travel ban under Presidential Proclamation 10998 affects both immigrant and non-immigrant visas for those countries. The Visa Bond Program has expanded to 50 countries with bonds up to $15,000, effective April 2nd, 2026. Tourist visas and other non-immigrant visas are not affected by the 75-country pause. Dual nationals with a passport from a non-listed country may be exempt. Keep your documents current, attend your interviews, follow the lawsuits, and work with a licensed attorney. If this video helped you understand what is happening, please hit the like button right now. It really helps this channel reach more people who need this information. If you are not already subscribed to US Updates Hub, please subscribe and turn on notifications so you never miss an update. Share this video with anyone you know who is affected by the 75-country pause or the travel ban. Check the description below for a summary of today's key points and links to official resources. Remember, policies can change at any time, so always verify information with official government sources. Thank you so much for watching. This is US Updates Hub, and we will see you in the next one. Stay informed, stay prepared, and take care of yourselves and your families. This content is for educational and informational purposes only. It does not constitute legal advice. Immigration laws and policies are complex and subject to rapid change. Individual situations vary significantly. Always verify information with official government sources, such as the Department of State, USCIS, or the Department of Homeland Security. Consult with a qualified immigration attorney regarding your specific circumstances before making any decisions.